Wednesday, March 3rd. I'm going to call this meeting to order. We'll have the invocation, and anyone's welcome to participate, but it's strictly voluntary. Commissioner Butler, will you start us in prayer?
Yes, thank you. Thank you, Mr. Chair. Father, help us to understand your guidance and your will. Help us to bend our will to yours, Father, and obey your holy precepts. Lord, we ask you to give us ears to listen carefully and a willing heart to carry out your directives. Lord, we ask for your wisdom, even when it doesn't conform to the wisdom of the world. We ask you to help us speak words that you want us to say to these people that come before us today, Lord. Let them know that we're willing to listen, that we understand what they're going through. Help us make good decisions today, Lord. We ask for your divine providence to watch over us, protect us all where we are. Thank you for saving us from this wretched disease that's destroying our state and our country. We ask for your continued providence and your divine blessings on us all. In your holy name we pray. Amen.
Amen. Thank you, Commissioner Butler. First of all, I'd like to thank you guys. Commissioner Butler, personally, thank you for taking the last meeting. I had COVID, so he had about a 24-hour notification. Actually, I think it was like 3 in the morning when I finally just said, you're in charge now. So thank you, Commissioner. I sincerely appreciate that. Tamara, will you call roll?
Yes, sir. Chairman Rick Figueroa.
Here.
Vice Chairman Tom Butler.
Here.
Dr. Ray Callis.
You're on mute, Dr. Callis.
Present. Sorry. Thank you.
Commissioner Helen Collier. Commissioner Nora Castaneda.
Present.
Commissioner Joel Garza. Dr. Gary Weston.
Here.
You have a quorum.
Mr. Chairman,
Yes, sir.
I would like to make a motion to allow the excused absences of the 2 commissioners that are not here.
Is there a second?
Second.
We're just going to assume any objection. Okay, thank you. Motion passes. Commissioners, a few quick reminders. Please make sure your camera is turned on an entire time. Mute your microphone when not speaking. Please raise your hand if you'd like to be recognized. I'll try again. There's a lot of you, so I'm trying to make sure that I've got you guys, and just wave at me like this, and I'll if I miss you for whatever reason, I apologize. And make sure you say your name before you speak so that we get it for the record. We're going to go to item C on our public. Oh, yes. Excuse me. Yes, on our public item C, public comments. Tamara, are you ready?
1 second, sir. I'll move the public commenter into the meeting.
Okay. So I'm going to read this to you guys. We're accepting public comments in writing or by video or conference call for those who submitted a request in advance to speak to the commissions. We'll bring first commentary in the meeting. The person will have 3 minutes to speak. We'll have a brief pause while we get to the next one, so just be patient. I think we got this down, and Tamara and Christine, thank you for the yeoman's effort that you guys are putting this through, and nothing like building a plane and flying it at the same time. So you guys have done an amazing job. So we have our first commentator?
Yes. Devorah Jabowski is our public commenter. I'm sorry, it's Jacobowski.
Devorah Jabowski, I'm sorry if I butchered your name. Can you hear me?
Yes, good morning.
Good morning. Did I come close to getting your name right?
It's Deborah Jakubowski.
Deborah Jakubowski. Good to meet you. Thank you for being here. Please say your name and who you represent. You'll have 3 minutes. Please understand the commissioners are not allowed to ask questions or engage in a discussion with you about anything that is not specifically on our agenda. Please also understand the commissioners cannot hear any information, pending case, complaint, or enforcement because they may ultimately be a decision maker in that case. Did you understand what I read to you?
Yes, I did.
Okay. You have, ma'am. Thank you again, and you have 3 minutes. Go ahead. You have the floor.
Thank you. Commissioners, good morning again. My name is Deborah Jakubowski, and I'm the Executive Director of the Texas Air Conditioning Contractors Association. I know how hard it is to read through every document in a meeting packet, so I'd like to read our letter to the Commission. TACA is grateful that TDLR waived the continuing education requirement for ACR contractor licenses renewing in March, April, May, and June of 2020 due to COVID-19. It was a huge relief for many of our members to have that load lifted during the pandemic. However, the impact on TACA was a significant decline in revenue from our CE program over a 3-month period, once contractors did not need to get CE for renewal. Our current CE course was approved effective April 1, 2020 through April 1, 2021, but due to statewide shelter-in-place orders, we were unable to hold classes until May 30th, 2020, and even into June, we had to cancel most classes or saw a steep decline in those classes that we did hold. Registration for our online version also saw a steep decline once contractors no longer needed to obtain CE for renewal. We are a small organization, and our CE program is a significant portion of our revenue each year. As a 501c6, TACA was ineligible to receive funds from the Paycheck Protection Program, and yet we kept staff paid through the pandemic despite the reduced workload to plan and prepare for classes that, again, due to shelter-in-place orders, could not be held. TACA lost 3 months of revenue from this essential part of our programming last year. For our members and our contractors in Texas, we're thankful to TDLR for removing a barrier for license renewal during the pandemic. For our organization, we respectfully request an extension for our CE course through the end of June 2021 to allow us a full year of utilizing the course. Thank you, and with that, I'm happy to answer any questions.
Thank you so much. We can engage on that, but what we'll do is I cannot tell you how much we appreciate as a commission and your feedback in unprecedented times. So, thank you for your comments, and we'll make sure staff follows up with you on this issue. Okay.
Great. Thank you so much.
Thank you, ma'am. Tam, is that it? Yes, I can. Okay, that's it. Okay, there we go.
Sorry, yes, sir.
Okay, thank you, Tam. Next item is D. I take a motion for us to accept electronic signatures.
I'll make that motion. Commissioner Wesson.
Commissioner Callis, second.
Any opposed? Thank you. Motion carries. Thank you. Minutes, commissioners, you have a chance to look at the minutes.
Motion to approve those minutes, please, Chairman. This is Commissioner Callis.
Is there a second?
I'll second.
Any opposed? All right, motion carries. We're going to jump into executive session. So let me read this to you. And I think, Tam, are you taking us into an executive session, or do we need to revisit, go back into the login to our different login?
No, sir, you'll have to go into your executive session.
Okay. Did everybody get their calendar for the executive session login? Did anybody not get it? Okay, I'm assuming that's good. Okay, I want to make sure we get it. So we'll go now into executive session to consult with our attorney under section 551.071 and 551.00712 government code. The time is 8:51. After the executive session, we'll take a break and we'll come back. Let's give ourselves, Brad, how long do you think? About 30 minutes? Or 40?
Yes, sir. I think that should be plenty of time.
So let's do 9:15. We'll do 9:15 and pick up with any action on executive session items and then begin the contested cases. Okay, commissioners, we'll see you in executive session. Thank you so much. let's start. Are we ready, Tam?
Yes, sir.
Okay. Its time is 9:17 a.m. I'm calling us back into the general session. There were no issues as far as on an executive session. So no actions needed on item G. We're back to contested cases. So Tam, I think we're going to switch up on contested cases. I think we're going to put Mr. Etabadi first. And so if anyone has indicated that they're appearing today in case, the staff has provided them with information on how to connect to this meeting. And we'll bring them into the meeting and we will announce the case. Tam, we're ready?
Yes, sir. I believe Mr. Itabari should be joining the meeting.
Mr.
Hi.
Etabadi?
Yes, hello.
Okay, good. Can you hear me?
Yes, I can.
Okay, good. I'm gonna read you some instructions and then we'll go from there. We'll hear from the prosecutor first and then you. We'll have an opportunity to speak. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak and up to 3 minutes for rebuttal. Tam, if you don't mind keeping track of that. Please understand the commission can only consider information that is in the record and that when the case was heard at SOA, so don't introduce any new information if you don't mind. And so you must limit your comments to those matters that were presented at the SOA hearing. So, Mr. Everybody, do you understand?
Understand.
Perfect. Okay. And any questions?
Was there gonna be like a short statement that I could make, or opening statement?
Do you have a particular question or comment in the beginning?
Yeah, just to talk about a little bit of my background, and then I think I was gonna have like 5 minutes, and then a
Yeah,
2-minute
so
to.
stand fast on that. I'm going to let the prosecutor go first, and then we'll switch to you. You'll have opportunity then, okay? If you have any
Okay.
questions, just let us know. Mr. Thielen, are you on?
Good morning, Commissioners. Trevor Thielen, can you hear me?
Go ahead, Mr. Thielen.
I'm a prosecutor with the Enforcement Division, and I handled this case at SOA. We recommend you accept the Administrative Law Judge's PFD proposal for decision and deny Ali Etabari's apprentice electrician license application. In 2015, when he was at age 29, the applicant committed indecency with a child by exposing the child to a 15-year-old. According to the probable cause affidavit, the staff at the 15-year-old's school became concerned when the applicant tried to bring her lunch after school. They contacted her parents, who found videos on the phone of a man having sex with the 15-year-old, and the 15-year-old identified that man as the applicant. In 2017, the applicant pled guilty to indecency with a child. He was placed on a 5-year deferred adjudication probation. He is currently complying with the terms of that probation, which included registration as a sex offender, and he is scheduled to be on that probation until 2022. In 2019, the applicant applied for an apprentice electrician license. Notably, he applied before the law that allows restricted licenses to be considered in cases like these came into effect, so that restricted license is not an option for resolving this case. He was 31 at the time of the plea, 33 when he applied, and he's 35 now. The ALJ found that the license could and should be denied because of the criminal history, and also because the evidence presented during the hearing did not establish the applicant has the trustworthiness required to be licensed at this point. Trustworthiness is important here because an electrician license would allow the electrician to potentially go into private businesses, into homes where minors may be present, and where both the applicant and the minor may be unsupervised. I recommend you adopt the ALJ's proposal for decision and deny the application. Are there any questions I can answer?
Thank you, Mr. Thielen. Any questions for Mr. Thielen? Commissioners? Okay. Mr. Etabadi, you have 5 minutes. Please, it's going to be hard, but just make sure you contain to the facts of the case if you don't mind, okay? You're on mute, Mr. Etabadi. You're still on mute. There you go. Did you hear me?
Okay. Yes.
Okay, you got 5
hello.
minutes. Go ahead.
I don't know if I can kind of tell you a little bit of my background and how it, I guess, following up to this. A little bit about my background. I grew up in Baton Rouge, Louisiana. My parents were immigrants coming into the U.S. My father was an engineer. My mom was a nutrition nurse. I was one of the 3 kids and the first in my family to go to college. But I have not finished my degree yet in international business. My first post-college job was sales associate in Exxon gas station. Early childhood, I accelerated through kindergarten, enrolled in advancement programs. At the age of 9, I built my very first website offline for a video game. And then by the age of 11, it went online, and it attracted 6,000 visitors per day from all over the world. Some of my hobbies back then were foreign money, stamps, collecting basketball, football cards, Power Rangers, Ninja Turtle sets, Legos, Connects, and Nintendo. Now I'm into traveling, cooking, my health, reading online, audiobooks, do-it-yourself projects. Concerts are a few things that I enjoy today. My parents have always told me to focus on school education, which is important to them. I've always looked up to my parents and want a greater life like them, if not better. My life wasn't so pleasant after 9 years old when my parents found a better job. We moved to other states prior to living in Texas. By the time I was in middle school, I was bullied because I looked different. Things got
I'm gonna
better
have to
after.
object. We've,
Can
I
you
haven't
help me?
objected
I need-
so far, but
You-
we're getting way beyond what's
Mr. Thielen, I
what's
got it.
testified back at SOA.
Mr. Thielen, I got it. Okay, so look, I wanted to, the background was just a general, where you're from. That's it. We want to skin. I'm telling you that it's very important to state the exact facts of the case. And so I appreciate the information, but that's not what we're looking for. We're looking, what in the case did you see a dispute with or have issue with?
Well, how I got into wanting to apply for a license is because I want to dip into the home market, and I want an apprentice license to work with master electricians on stuff like light fixtures, doorbells, light switches are very common requests. How I got into electrical has something to do with my childhood. I was plugging a lot of things into receptacles, and I accidentally caused a spark.
I got it, but we
putting metal
got to state of the case. I want you to tell me.
Absolutely. Well, it the, it I it's I don't know how to rebuke this other than just that this what happened to me was a guilt, and it the facts sound like really bad when it's presented to you guys, but things have changed, and things have changed since my father passed away, but he was an electrician and I didn't have him, unfortunately, to have him kind of support me in the licensing. So and so since it's passed away, well, I've always been the same guy. What happened, what I did was a mistake. I didn't know. I've been very sheltered from the bad things. So I took that guilt, and I don't need someone to tell me what I've already done. I know my mistakes, and I'm owning up to it. And it's something that it's not something that's gonna go away. I'm still fighting, like I'm fighting with you guys to have a license, because your decisions affect where I'm gonna go. And I'm just trying to, better my life, better my future, and take care of my family, especially.
Okay.
And I've
Sure.
helped, and I like to help a lot of people. My priorities are not to repeat what I did before.
Okay. Okay, Mr. Everybody, your time's up. Thank you. I know it's a tough lane, but we're going to go to the commissioners to see if they had any comments or questions. So they'll address you, and make sure you address them as commissioner. Thank you. Commissioners, any questions or comments for Mr. Thielen or Mr. Everybody? Okay. All right. Well, then I'll entertain a motion.
I make a motion that we deny the Mr. Edibari's request to have his license, accept the ALJ's determination. And that's my motion.
Second.
I second that.
Okay.
Commissioner Castaneda.
Okay. Thank you, Nieta. Any discussion? Okay. Good. Okay. Well, then take a vote. We're going to do all in favor say aye. If I hear a dissent, I'll do a roll call vote. Okay. We'll just, I think that's the best way to do it. So all in favor say aye.
Aye.
Any opposed? Okay, motion carries. Mr. Adibody, you can get with staff. There's some other things that you can do. They'll be happy to follow up with you. Appreciate your time tonight or today. We appreciate your efforts, but if you have any questions, they'll contact. You can contact them directly. Okay.
Thank you.
Okay, Tim. We're going to back up to case number 1.
Yes, sir.
Mr. Brandon Allen.
Mr. Allen is not present.
Okay. All right, Mr. Thielen, you there?
I'm here.
Okay. You have the floor.
Good morning, Commissioners. Trevor Thielen with Enforcement again. Ken Sharp handled this case at SOA before he retired. He previously heard the case and decided upon it in December to uphold the PFD. Then a motion for rehearing was filed and granted, so you're hearing it again today. We ask to accept the administrative law license proposal for decision, which recommends that you revoke Brandon Allen's Class A barber license. Mr. Allen was granted a barber license in 2014. He renewed it in 2016. In 2017, at age 34, he was placed on deferred adjudication for manufacture, delivery, possession with intent to deliver cocaine, a felony offense that is directly related to the barber occupation based on concerns that a barbershop could serve as an effective cover for a drug dealing operation. This specific offense occurred in the parking lot of a grocery store. He was placed on a 5-year probation, which he violated in 2018 when he committed another felony drug offense, this time possession of methamphetamine, but with no delivery or intent to deliver enhancements to it. The court did not revoke his earlier probation for this new offense, but it did send him to a rehabilitation facility in 2019. While there, Mr. Allen's mother renewed his license without his knowledge and gave an incorrect answer to the question on the application of whether or not he had any new deferred adjudication. Mr. Allen had never mentioned this explanation about the criminal history question to Mr. Sharp until the hearing. The ALJ considered 2 issues: whether the license should be revoked based on the false answer on the renewal application, and also whether it should be revoked based on the criminal history. The ALJ found that the evidence did not show respondent's license should be revoked based on the false answer because of the explanation about respondent's mother filling out the application, not the respondent. However, the ALJ did recommend the license be revoked based on the criminal history alone. To be clear, the directly related offense that empowers you to act in this case is the cocaine delivery, manufacture, possession with intent to deliver offense. The ALJ found that offense was serious. It was committed when Mr. Allen was clearly an adult, and that being a barber would provide an opportunity to commit further similar crimes. The ALJ also found the methamphetamine offense was relevant to this conversation because it, along with the respondent's testimony during the hearing about his past drug use, past relapse, made it clear the danger of the respondent making future bad choices in the course of subsequent relapse. Though there was some evidence of respondents spending time in a rehabilitation facility in 2019, the ALJ ultimately felt that the 2017 offense was too recent and not enough time had yet passed to demonstrate the respondent is fully rehabilitated. The ALJ recommends you revoke the license. We recommend you accept the proposal for decision. Are there any questions I can answer?
Any questions for Mr. Thielen? Okay, I'll take a motion. I think there's some technical corrections on this one as well.
Mr. Chair, I'd like to make a motion. This is Commissioner Callis.
Yes, sir.
I would like to accept the ALJ's decision with the PFD, and also please remove the technical corrections, including the words intentionally. And I would and any other technical corrections that Mr. Bowman might see in order to allow us to support this PFD.
Mr. Chairman, Brad Bowman, General Counsel, the technical corrections we were recommending are finding of fact 1 and 6, and then in conclusions of law 5 and 6. That's the issue that Dr. Callis was just mentioning, with the word intentionally not being the quite accurate way to describe the legal standard for misrepresenting something on an application. So we would recommend your motion include those changes.
Mr. Chairman, that is my intent, exactly what Mr. Bowman just said, just to be completely clear for my motion to support the PFD.
And I'll second that, Commissioner Wesson.
Excellent. Thanks for your clarity. Thanks, Mr. Bowman. All in favor, say aye.
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 Mr. Butler, you're on mute.
I'm sorry, aye.
Okay. Any opposed? Good. Motion carries. All right, we're going to case number 3. Are you ready, Tam?
Just a moment, I'll bring Ms. Kolojoko into the meeting.
Okay. Ms. Kolojoko, can you hear me? You're on mute. Ms. Kolojoko. Ms. Kolojoko, can you hear me?
I can. Thank you.
Okay, okay. I want to make sure that you're able to speak. I'm going to read you some instructions if you don't mind, and then I want to make sure you understand them. So we'll hear from the prosecutor first, and then you'll respond. You'll have an opportunity to speak. Make sure you speak clearly. Say your name and who you represent. Each side will have 5 minutes to speak. We'll keep tabs on that. There may be a 3-minute rebuttal. Please understand, and this is clear, Ms. Kolojoko. Can you hear me? Can you hear me?
Yes, I can hear you, just not, you're very soft, but I'm trying.
Okay, we can barely hear you, so I want to make sure that if you can turn your volume up, or if you can get to a place where it's pretty stable, that'd be great. Okay, can you hear me?
I can hear you, it's just soft.
Okay, we're gonna have to when you speak, you're gonna have to speak up loud so we can hear you. So let me finish this, and then we're gonna hear from Mr. Thielen. Please understand the commission can only consider information that is in the record from the case that was heard at the SOA. So we don't want to go outside our lane. It's going to be difficult, and everybody has challenges with it. But just stay with the cases that were in the SOA hearing. You must limit your comments to those that were presented there. All right? Do you understand, Ms. Kolojoko?
Yes, sir. Yes, sir.
Perfect. Okay, Mr. Thielen.
Trevor Thielen with the Enforcement Division. I'm the prosecutor who worked on this case and for the SOA. We recommend you accept the administrative law judge's proposal for decision and revoke and deny renewal of Allison Elizabeth Kolojako's speech language pathologist license. The respondent has been licensed since 2002. In 2015, she was convicted of her first DWI. The officer saw her drive with a turn signal on for an unusual period of time without turning, saw her weave within her lane, and saw her stop at an intersection for 30 seconds when she had multiple opportunities to proceed through it. She failed the field sobriety test the officer gave and was arrested. During that DWI, while she was driving, she had 3 passengers in the car with her, an 11-year-old child, a 7-year-old child, and a 3-year-old child. She received a 1-year probation and she completed it successfully in 2016. In February 2019, the respondent got her second DWI conviction. The officer in this case found that she drove her car into a ditch. When he looked inside her car, he found 37 wine bottles, 3 unopened, 2 opened with some wine still inside them, and 32 empties. She received a jail time sentence for this offense. 8 months later, in October 2019, the respondent received her third DWI conviction. A witness saw her swerve in and out of her lane, stop in the middle of the road, and then drive into a ditch for a second time. The officer found 2 containers of wine in the car and an open, still 3/4 full and cold can of beer. The respondent was confused about where she was and at one point tried to leave the scene, telling the officer she just wanted to go stay with her kids. Because she was now convicted of a felony DWI, this being her third DWI, the court sentenced her to 10 years in prison. However, the court suspended the sentence and put her on a 5-year probation. She was 1 year into that probation at the time of the hearing, which she's scheduled to complete in 2024. TDLR never received independent confirmation that the respondent is in compliance with her probation, though the respondent testified at the hearing she is in compliance, and we don't have any evidence of non-compliance. The respondent did testify about her ongoing rehabilitation efforts, and she also presented supportive testimony from her licensed chemical dependency counselor. However, after reviewing all of the evidence, the ALJ ultimately concluded that not enough time has passed since the most recent of these 3 offenses to demonstrate her fitness to be licensed or that she has the trustworthiness required to be licensed. Speech-language pathologists interact with clients, often those who are either children, the elderly, or the disabled. Intoxication of the licensee who's performing these duties could not only physically endanger the clients they contact, but also affect the exercise of judgment and observation that is essential to the services they provide. The ALJ recommends you revoke the license and deny the renewal. We recommend you adopt the PFD as written, specifically the second corrected version of the PFD that the ALJ issued on February 3rd, 2021. Are there any questions that I can answer?
Any questions for Mr. Thielen? Commissioners?
I'm not real sure what the February 3rd, 2020.
Ms. Kolojoko, hang on a second. Okay, so we're talking. Okay, I want to make sure you have 5 minutes. Your fainted voice, so I want to make sure the commissioners have a chance to hear you. So whatever you need to do to make that voice louder, that'd be great. We're going to keep time. Please, again, stay within the facts of the case that were presented, so we don't want to stray outside that lane. Okay?
Yes, sir.
You have the floor. And commissioners, if you can't hear her, please wave your hand or let me know. Go ahead.
Well, I was commenting because I'm not real sure what the February document that he was talking about on the 21st, or 2021. I recognize my history with alcoholism. It's obvious. It's black and white. I also recognize that I am a great speech pathologist. I have been practicing since as an assistant and then on after my graduate program for my entire career. I am an alcoholic, and I'm very proud of my length of sobriety, which is beyond a year, and I work very adamantly to ensure my program is first and foremost in my life. And I just would like an opportunity to practice. Mr. Gardzina presented at my case, thought that maybe I would discuss working on a probationary basis. And I guess I won't be lengthy. I realize it hasn't been a long time for many people to recognize my length of sobriety, but I also feel like there's a lot of patients that would benefit from my services, and I've been a wonderful practicing speech pathologist all my life, so I just like the opportunity to continue. So, and that's it.
Okay, thank you, Ms. Kolojoko. I appreciate it. I'm going to throw this to the commissioners. Commissioners, just state your name so she knows which commissioner she's speaking to. If you have any questions for Mr. Thielen or Ms. Kolojoko.
I have a question for her. Hey, this is Commissioner Dr. Callis. My question, Ms. Kolojoko, I have for you is, are you employed right now?
I am. I have 4 little boys, and so I'm providing for them the best I can. I work at Goodwill.
Okay. Also, too, how many? I know that alcoholism is a severe disease, and I respect you're going through the right steps. You first admitted that you do have a severe problem. That problem is definitely important for you to admit first as you start to heal through this process. I'm also very proud to see that you've also had 4 or 5 urine drug screens that have been negative for alcohol. So, I mean, you're going down the right path. But I will just tell you that I pray for you to continue doing what's appropriate. And thank you for being admitted that you have a problem. And it's not embarrassing. It's a disease. And I just wanted to make sure the other commissioners hear what I had to say. And I'm glad that you're on a correct path and continue your sobriety. Thank you.
Appreciate that.
You're muted, Chairman.
Any other, thank you, Commissioner Callis. Is there any other comments?
I feel compelled I agree with my fellow Commissioner Callis. Ms. Kolojoko, this is a hard one for me, and usually these are not. I just want to commend you for the steps that you've taken, and keep up the work. I don't know what the commission is going to decide, but you have a life to live outside of your license, and don't waste the rest of your life looking back on the mistakes that you made prior to the change that you decided to make. So, best of luck to you. Above a speech pathologist, you're a human being, and you need to take care of yourself.
Thank you, Commissioner Butler. Commissioner
I wanted
Castaneda.
to,
Oh, go ahead. I'm sorry. Who was that?
I wanted to just note the corrected version of the PFD was a very minor clerical correction. They mistakenly referred in the conclusion of law number 1 to the electrician statutes. So it was corrected to refer to the speech language pathology statutes in the second version. But otherwise, the PFDs are identical.
Thank you, Mr. Thielen. Commissioner Castaneda, I just want to give you a chance if there's any comments.
No comments.
Okay. All right. Any other comments?
I had a question for Mr. Thielen or Mr. Bowman, if it's okay, Chairman.
Yes, sir.
Hey, this is Commissioner Callis again. My question is that if we follow the PFD, can Ms. Kolojoko ever have an opportunity to apply for speech pathology license? I just want to hear some avenues that before I make my decision, if you don't mind.
Yes, I think I can address that pretty quickly. A revocation of the license is not permanent. There's no law here that's going to permanently disqualify her like there may be if it were a massage case with a sex offense. This is basically saying we're going to take the license away. There's a law that says she has to wait 1 year from the effective date of that revocation before she can apply for a new license. At that point, we would do the same criminal history evaluation that we do normally at the start of any original license. If she still meets the other license licensing requirements for the license, that would be a separate matter. Um, I can't guarantee she would or she wouldn't, but generally they will look at the same stuff again. Sometimes these folks have to retake an exam, other times I don't know that they do. But as far as criminal history goes, we would take another look at where she is at the time that she applies in the future and make an independent decision based on those facts and not be beholden to what happens during this case.
Thank you very much.
Point of clarification, Mr. Thielen, that date of effective date would be today, or would it have been when? What date would, from 1 year, for what day would that be?
I would defer to Brad on that one.
Can
Yeah,
I
Brad?
thank, yeah, Mr. Chairman, it's Brad Bowman. The order, if you were to enter an order today revoking the license, it doesn't take effect right away because there are some time periods that sort of have to elapse. So Ms. Kolodziejko would have an opportunity to file a motion for rehearing, so that there's a 25-day period for that. So that period has to run. And if she does file a motion for rehearing, you can rule on that down the road. So it's your order would not actually be final until that time period has run. So it's a little variability in it, but it's at least 25 days. And then if she does file a motion for a hearing, when you finally rule on that, that would be when the revocation would actually go into effect. So then a year from that point would be the bar on reapplying for the license.
This is Commissioner Butler. Mr. Bowman or Mr. Thielen, how much time is left on the current license belonging to Ms. Kolodziejko?
The license is currently expired. However, because she renewed timely, the law recognizes her license as active during the pendency of the case. Essentially, until that date that Brad just identified as the effective date of the order, she has a license, even though on our website it's going to show revoked. To help with this situation, during the hearing I offered and followed through the next day on sending her a letter confirming this legal analysis and that we would honor her license as being effective during the pendency of the case, and directing questions to me if somebody these questions about what's the situation. I would confirm that she has an active license until the effective date of an order revoking it. And if the case went the other way and you granted the license, then that wouldn't be necessary. She could renew it soon after this meeting.
So if we were to revoke her license and suspend that revocation contingent upon negative UAs for alcohol in her court case, how long could we supervise that suspended license? How long till her next license expiration date? Would it be 1 year, 2 years?
I'm not certain. I could try to find that out for you real quick, but I don't have that offhand.
Mr. Chairman, I have a question for Ms. Kolodziejko again, please.
Yes, sir.
Hey, this is Chairman Callis again. How long have you been sober?
My last DWI was in September the 16th of 2020.
September 6th. So we're talking about 5 months ago, correct? 2019. Okay, 2019. All right. Since that time, I need you to stay focused and not freak out. I'm going to ask you a serious question. Are your urine drug screens, are they randomized or are they scheduled?
Actually, I'm in. So I started right after my DWI. I started supportive outpatient. So that was January, and then I went through. I've been in treatment for the entire last year. So they are all random. I took one Friday, actually. They're very.
But what I'm saying is that you deciding to take these, or is someone not scheduling them and doing them randomly?
They do them.
Say again?
They do them. I'm in a supportive outpatient, and they just call me, tell me.
Okay, so whenever they call you, this is very important for me to ask so the commission can hear you. Whenever they call you, do you have to respond within 1 or 2 hours, or you can come in the next day?
Or you'll have to repeat that question. For some reason, I didn't.
If you get called by your support treatment facility, how long do you have to respond to that urine drug screen? And whenever you do that urine alcohol screen, are you supervised when you're doing that screen?
Oh yeah, absolutely. Are supervised, and it's immediate.
Okay.
You go in whenever they call you, and you're very, very much supervised.
And how many times have you been negative now, and how many times have you been tested?
Oh, I've been negative all through the year last year. The amount, I've never counted the number. Mr. Gardzina is actually the one that was just trying to reach us to talk about this too, I'm sure. But he dozens, handfuls, 20 maybe would be my guesstimate. They call, I go.
I can summarize the testimony that was presented from Mr. Gardzina at the hearing according to my notes. But first, let me answer Mr. Butler's question. This would be a 2-year license term for speech-language pathologists. Mr. Gardzina testified that the respondent started an inpatient intensive program. She graduated on September 30th of 2020 to the intensive outpatient program, which she was still in. He's testified that that program lasts 6 to 8 weeks. We were in the middle of that when we had the hearing. He said if she passes that assessment at the end of that 6 to 8 week program, she'd move into the supportive outpatient program, which would last 3.5 to 4.5 months. And then if she passes that, it would go to a voluntary program. He testified about the analysis tests that they were giving and testified that she was sober since going in. She had weekly randomized urinalysis, and she had been given one of those each week, although we acknowledged there were 2 different types of tests, and that 4 out of the 6 tests only looks back 3.5 days. So, the implications from that testimony, there was not every day has been accounted for according to these tests, but that every time they have given the tests, it has been negative for alcohol. So that was the testimony that was presented, and it's all as of the date that the hearing was held. Any testimony from Ms. Kolajaco or Mr. Gardzina that is about what happened after the hearing, although it would be of interest to the commission, I would submit it's not something you can consider when making your decision on this case.
Thank you, sir.
Great. Thank you. Any more questions, Dr. Callis? Are you good?
No, I'm completely clear. I just want to make sure all commissioners understand that this is not, this is a disease, and I want to make sure that you understand this is a medical diagnosis that Ms. Kolajaco has. That's all I'm trying to make it very clear. That I'm torn right now, and you can hear that I'm torn. I wouldn't be asking all these questions because this is not clean and cut in my mind. Because me being a physician and working and having to deal with alcohol and drug abuse related to many physicians in my career, I've made decisions to suspend, and I've also made decisions to let them come back and work. So I just wanted to let y'all know that sometimes we do more harm by revoking and not letting these people get back in the workforce, and sometimes we make the wrong decisions by doing that. So that's where I'm split, Chairman. I just wanted to be clear to the commission.
Mr. Chair, if you'll entertain a motion, I'd like to make a motion, Mr. Chair.
Just give me one more second because Dr. Callis introduced a lot of information. I want to make sure that all the commissioners had an opportunity to absorb that. Commissioner Castaneda, any questions?
No questions. I'm listening.
Okay. All right, Commissioner Butler, and go ahead.
Mr. Chair, I'd like to make a motion that we revoke Ms. Kolajaco's license, but suspend that revocation contingent upon her success in continuing the negative alcohol urine analysis. I think she can be, based upon her decisions, a functioning, contributing member of this society, whether she's a speech pathologist or not. But I'm willing to give her a chance. And so that is my motion. I would like to set that aside for a second, Ms. Kolajoko. We are supporting you, but also at the same time hanging something over your head that you could potentially lose based upon the decisions that you make. None of us are beyond God's reach, and my prayer is that He has reached into your life and you turn it around. You have all the hand in this. And so, Mr. Chair, that's my motion.
Thank you for your motion, Butler. Is there a second?
This is Della. We need to talk about changing some findings of fact and conclusions of law. If we're going to do that, we would need to make amendments to the PFD in findings of fact 16 and 17 and conclusions of law 14, 16, and 17. And I need to know how long do you want the probation to go for, Mr. Butler?
So thank you, Ms. Lindquist. I'd like to amend my motion to include the findings of fact and conclusions of law that Ms. Lindquist enunciated for us. Would you like me to repeat those, or can I just?
Need to give the dates for how long do you want this?
Sure.
Is that accurate?
I would like it for the remainder of her license term. If she gets a new license for the remainder of that term, which I think is 2 years, if I understand Mr. Thielen correctly.
She's asked for renewal of the license, so when you issue your order, if it's to renew the license, then that license term is 2 years before she has to do anything further.
I would like it 2 years. I think this both supports her and you know, and there's a punitive measure if she you know, decides to make those steps as well. So I think 2 years is okay. Just my opinion there. That'll be part of my motion.
Mr. Chairman.
Thank you, Commissioner Butler. Before I get the second, let me be clear here. So you want to suspend, right? Or revoke the suspension, revoke and the suspension, correct?
I think he said revoke the license and probate the revocation.
That's what probate the revocation. That's what I'm looking for. Okay. So you can probate the revocation for a 2-year period.
Correct. Correct. Yes, sir.
And the condition is that there's no failing any of the drug or alcohol testing during that time.
Yes, sir.
Is that accurate?
Yes, sir, it is.
Did I get that right? I want to make sure I get that one. And then finding of law 16, which talks about her ability to be, is that right? We're taking issues with the 16, and which other one? Facts of finding?
For finding of fact, it would be 16 and 17.
Okay.
And for conclusions of law 14, 16, and 17.
That's what I got. Good. Okay, that's the motion. Commissioners, are y'all clear on the motion? Is there any questions on the motion? Okay, is there a second to that motion?
I'll second it, Commissioner Wesson.
Commissioner Wesson, second. Okay, all those in favor of that motion?
I want to discuss, please.
Okay.
This is Commissioner Callis. I appreciate Commissioner Butler's motion, and I appreciate Dr. Wesson's seconding. Here's my question, and it's a two-part question. One, for the next 2 years, if she's not in any treatment program anymore, how are we going to make sure that she is submitting randomized urine tests? Also, two, I'm just making it very clear, I don't think it should have a time frame of 2 years. I think once you become an alcoholic, you're sober for the rest of your life. And I mean, I always deviate from the contract that these physicians sign, that it's not just a 2-year grace period, it's forever. So what I'm saying is that I would like to make sure if any time she pops positive for a urinalysis with alcohol, no matter when it is, the license should be revoked.
So are you amending Are you offering to, I'm sorry, you offering to amend the motion, Dr.
Yes,
Callis?
I'm offering a friendly amendment to help Ms. Kolojoko because she should not have a goal of just 2 years. She should have a goal of lifetime sobriety. And the reason why I'm making it a lot more stricter is because I'm trying to give her the best help possible for the remainder of her lifespan.
So we would have to have her on some kind of probation for the rest of her license term?
Della, I'm just trying to figure it out because you know what? I don't like giving someone a chance just for a couple of years and then all of a sudden they think that they're scot-free. If she really wants to be sober, we still have to monitor her somehow. That's my personal opinion.
Right. I just don't see a way to revoke her based on that unless she's under some kind of terms and conditions.
So I think currently she lives in a sober living environment, and she's still, like, you know, as late as Friday this past week, she was tested. So my understanding is that when you're living in those environments, they do periodically randomly test you. And so as her conditions change, as she progresses through her treatment, it'll be less restrictive. She'll be able to live out on her own and that sort of thing, but still come back. It's kind of a graduated sanctions, right? She'll still come back for testing, therapy, that sort of stuff. So I don't know when that'll run its course. Oh, I'm sorry, Mr. Bowman, please.
Oh, and I didn't mean to interrupt you. I was just going to chime in on Dr. Callis's question about the time frame.
Please do. That'll help give us some context. Mhm.
Well, one thought would be you could have a longer probation period. So right now the motion is for 2 years. You could lengthen that. I don't know how procedurally to do that forever, but you could make it a greater length of time, and she will come up for renewal, and the department could look at you know, where she is in her compliance, you know, at that point, and if there needs to be some other action taken, that could be looked at down the road. So that's a thought. Is if you're not comfortable with the 2 years, to have a longer time frame where she would have to do the drug screen, the alcohol and drug screening, and with those terms of probation.
So I want to quickly address, and maybe Ms. Kolojako can fill us in on some of this. We had UAs being provided by the inpatient place that she was at. She's still on probation. I believe it was until 2024. As part of her probation conditions, they're requiring that she not use any alcohol. So perhaps what she's referring to with the UAs is a test given by her probation as opposed to whatever rehab facility that she was in. I don't know that. I'm making a lot of guesses here, but and I'm making guesses. She's going to continue to give those, but that is some vehicle that might be there after the rehab UAs are done to possibly be an avenue for when things are positive. Now, whether we will know if she gets a positive one or not is unclear to me.
Okay, so let me I get Mr. Thiel, I got what. So, Dr. Callis, I know what you're trying to go for. So right now the motion is for 2 years. I don't think there's a feasible perpetuity, but to Mr. Thielen's point, we could continue this for her probational period, which is to 2024, which extends it further than the 2 years that was proposed by Commissioner Butler. So that's what's on the table. I want to make sure that we don't go down too many rabbit trails here, but I want to make sure we get the dialogue straight. You're on point right now on trying to offer amendment. What's your response, Dr. Callis?
My response is that I would like to follow our attorney, Mr. Thielen's advice, because if she is mandated by her probationary period till 2024, we should be able to know if she ever becomes positive for a urinalysis due to the fact that that would revoke her probation, and then she'd be in a lot more trouble, you know, so to speak. One thing I don't want to do is that I wanted to make sure that we are protecting the citizens of Texas, but also not handicapping her to where she can't work. And so I appreciate Mr. Thielen, Mr. Bowman. I'm totally fine if Mr. Butler would accept a friendly amendment that we would keep her on probation as long as her probation is that is mandated by the court until 2024.
Mr. Butler, are you good with Commissioner Butler? Are you good with that?
Absolutely, Mr. Chairman, and that's why this board does such great work, is because we listen to one another, and reasonable minds are going to be able to differ on these sorts of things, and reasonable minds can sometimes come to the same conclusion. And so that's a great amendment, and I would like to change my motion to concur with her probationary period, which I understand is 2024. So thank you so much, Commissioner Cowles.
Is there a second? Dr. Weston,
Yeah, I'll put a second on that.
Okay. Any further discussion? Okay. All those, Commissioner Castaneda, you're good?
No questions.
Good, perfect. Thank you. All those in
I'm
favor
going
say
through
aye.
the vote.
Aye.
Any opposed? Okay, motion carries. Ms. Kolojoko, do you understand what just happened?
Not 100%.
Okay, let me be clear here, Ms. Kolojoko. It's an extraordinary effort that went before us right here. I'm not sure where your head is on this, but let me be as clear as I can. As the commissioners have painstakingly walked themselves through this publicly, that's what we're here for. But making no mistake, it is on behalf of the constituents of the state of Texas to have people who do a good job in their vocations. And so take responsibility for that as well as the sobriety that you're walking down. I hope we don't see you again. I wish you the best, and you're going to need to follow up with the staff for any clarifications, okay?
Okay.
Thank you, Ms. Kolojoko.
I appreciate every single bit. And
Okay, have a good day.
recognizing
Thank you so much.
Thank you
Okay,
so much.
Tam?
Mr. Chairman,
Yes, ma'am. Yes, sir.
I just want to thank all the commissioners and staff and the attorneys for understanding, because this is very emotional for me, because we are at the threshold of protecting our Texans, but we're also at the threshold of letting people know that it's okay to admit they have a disease. And so I just want to thank everyone and all the commission, and thank you, Chairman, for walking us through this hard case, and I really do appreciate it.
Okay. Thank you. Dr. Callis, your insight is invaluable, as well as all the other commissioners, but thank you for your medical insight. Thank you. Tam, Mr. Blackwell here is not on. Is that accurate?
That is correct, Chairman. We're having some connection issues with her and we're working with her. So can we go to the next case?
I think that's possible. Just let me catch up with you if you don't mind. The next case will be Beckhold. Is that accurate?
Correct.
Okay. Beckhold number 4. And the prosecutor is, who is prosecutor on this?
That's Morgan Cumming.
Okay, Morgan Cummings. Thank you. You threw me off when we switched gears here. Ms. Cummings, are you on there? Ms. Beckhold, are you there?
I am here, Prosecutor Cumming. I do not believe Mr. Director Beckfold is here.
Okay.
That's correct.
Okay, Ms. Cummings, if you have the floor.
Good morning, Commissioners. My name is Morgan Cumming, and I am a prosecutor with the Enforcement Division. Because of the sensitive nature of this case and the required statutory confidentiality provisions, I will refrain from using the complainant's actual name and refer to her only as the complainant during this public meeting. I recommend you accept the Administrative Law Judge's proposal for decision and revoke Mr. Brian Curtis Beckfold's, the respondent's massage therapist license, for engaging in sexual contact during a massage session with the complainant without the complainant's consent. On April 2nd, 2019, the complainant filed a complaint with the department regarding a massage she received March 29th, 2019, that was performed by the respondent. The complainant, who had just lost her husband and was suffering physical pain stemming from a disability, was giving a gift from her sisters for a 90-minute Swedish massage. The complainant testified during a hearing that was held on October 20th, 2020, via a Zoom video conference, that she received a normal massage for the first 85 minutes, and then the respondent touched her vagina without her consent. Because of the respondent's conduct, the complainant testified she will never get another massage. The respondent denied he inappropriately touched the complainant. The complainant's brother and sister-in-law corroborated her testimony, as did Belton Police Officer Dwayne Rabazi and Belton Police Detective Robert Preston. The Administrative Law Judge found the complainant's testimony credible and persuasive, and she exhibited appropriate emotional anguish during her testimony at the hearing. The ALJ found by touching the complainant's vagina during the massage, the respondent engaged in sexual contact during a session with the client, and this contact was not only serious but also willful or intentional. This is a violation of the massage therapy rules, and pursuant to the department's enforcement plan, the suggested penalty is a $5,000 administrative penalty and/or revocation. In order to protect the health and safety of Texans, the ALJ proposed the respondent's massage therapist license be revoked and no administrative penalty be assessed. The department recommends you adopt the PFD as written and revoke massage therapist license MT128529 belonging to the respondent, Brian Curtis Buckfold. If you have any questions, please feel free to ask.
Questions, commissioners? I'll entertain a motion.
I'd like to make a motion, Chairman.
Accept the PFD. Is that what you're saying?
Yes, sir. I would like to accept the PFD and also assess a $5,000 penalty, and also make technical corrections as needed. The reason why I think a penalty is warranted is because any type of sexual assault, in my opinion, is not just revocation. I think that once a woman's, man's, child's personal space is violated, I think that is unequivocally some of the worst behavior that we have to deal with. And so I would like to assess the $5,000 penalty as well as filing the PFD with technical corrections.
Is there a second? Oh, Brad, go ahead.
Well, I just wanted to suggest that we would need to change perhaps some conclusions of law in doing that. And from what Dr. Callis just described, I think in assessing a penalty, you have to look at certain factors. So some of what he just laid out, I think, does that. It's the severity of the offense and the relationship of that to this type of licensed occupation. And so we would need to cover that in part of your written order in a conclusion of law. I don't have the number handy, but we will. I would recommend that your motion include that change.
Would it be?
Yes, sir.
Yeah, okay, I think it'd be conclusion law 12. I think somewhere in 12, right? That's what I'm looking at. Or 11. Is that accurate, Brad? Brad? Can y'all hear me? Okay.
I don't know if Brad's heard it.
Brad, can you hear me?
It would be, I'm sorry, I was scrolling through the PFD very quickly. It would be conclusions of law 12 and 13, what it looks like to me,
Right.
would be the ones to address that.
Are you good with that, Dr. Callis?
Yes, sir. I'm totally fine with that, sir.
Motion.
Second the motion. Any discussion? All right. All in favor, say aye.
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 Opposed? Motion carries. All right. Thank you, Ms. Cumming.
Thank you, commissioners. Have a wonderful rest of the day.
Thank you.
You too. Tam, are we going back to Blackwell? Okay, they're not on yet. So let's go to Daryl Glenn Johnson.
Yes.
Jessica, are you on?
Yes. Good morning, commissioners.
Good morning. Good morning. Okay, so is Mr. Johnson on? Is he in?
I'm putting them in right now.
Mr. Johnson, can you? Mr. Johnson, can you hear me? You're on mute. You're on mute, Mr. Johnson.
Okay, can you hear me?
Yes, I can hear you. Can you hear me?
Yes.
Okay, you're gonna have to speak up. I'm gonna read some instructions to you, and then we'll go from there. Okay?
Okay.
Okay. So let me read this to you. We'll hear from the prosecutor first, and then you, you'll have an opportunity to speak. Make sure you speak clearly and especially loud. State your name, and each side will have 5 minutes to speak, and you'll maybe a rebuttal of 3 minutes. Please understand that the commissioner can only consider the information that was at the SOA hearing, which means only those facts. If there's any questions or anything you want to add is in that SOA hearing, that's what we want to contain the hearing to. Do you understand, Mr. Johnson?
Yes.
Okay. Okay. Jessica, where are you at? I lost you.
Yes.
You there?
Yes.
Okay.
Can you hear me?
Yeah. Okay, there you are. It's a Hollywood Squares. Everybody moves, so I don't know. But okay, you have the floor.
Good morning, Commissioners. My name is Jessica Hurtado, and I am a prosecutor in the Enforcement Division. I recommend that you accept the ALJ's recommendation and revoke Daryl Glenn Johnson's massage therapist license as required by law. The department filed a motion for summary disposition in this case, and the respondent did not file any response to that motion. The ALJ granted the department's motion and issued a PFD without the need to hold a hearing. This case involves the mandatory massage laws that you have considered in previous cases. In each case, you have consistently applied these laws, which leave you no discretion but require that you revoke the massage therapist licenses. We recommend that you continue to do so in this case. The Department of State Health Services issued Mr. Johnson a massage therapist license in 2016, and the department learned about his criminal history when Mr. Johnson applied to renew his license in October 2019. In 1993, respondent pled nolo contendere to the offense of aggravated promotion of prostitution, an offense under Texas Penal Code Chapter 43, Subchapter A. Mr. Johnson received 5 years deferred adjudication community supervision. The law is clear. Mr. Johnson was never eligible for a massage therapist license, and you are now required to revoke that license. The ALJ granted the department's motion for summary disposition, and respondent did not provide any evidence to the ALJ. I recommend that you adopt the PFD as written, and I'm available to answer any questions you may have.
Thank you, Mr. Hurtado.
And Mr. Butler, can you mute your phone or your computer so we can hear the pages and all that we're flipping, sir?
I'm so sorry.
All right. Any questions for the prosecutor?
Mr. Hurtado, can you explain, don't we have law that prostitution, it's automatically revocation based on Texas statute?
Yes, Commissioner, this offense that he was convicted, he was placed on deferred for the aggravated promotion of prostitution. It's within that subsection that the statute says is automatically makes you ineligible and makes your and makes that that license.
Thank you very much.
Okay, thank you. Any other comments? Okay, Mr. Johnson, can you hear me?
Yes.
Okay, you'll have 5 minutes. You don't have to take the whole 5 minutes, but please contain any facts finding within the SOA hearing, okay?
Okay.
Go ahead.
Okay, my name is Daryl Johnson, and yes, I was charged with aggravated promotion of prostitution 27, almost 28 years ago. Okay, I was a young man. I owned a business that was not providing for any type of prostitution or anything. But Fort Bend County decided to basically bait me in and trap me with that, so they could charge me something. They charged me with something. Possibly, I don't know. It was supposed to be a drug thing, but they pulled me into it. So I accepted the deferred under the understanding that if I completed the probation, all that would go away. Okay, when I completed the probation, didn't go away, obviously. And I've been through this before with TDLR for my record license, and I provided all the information I needed to provide, and they granted me my record license since 2008. These right here. They expired in 2015. Okay, now I understand your laws as far as the massage industry, but I also went through this same process with the massage board, and they granted me the license. Okay, so it was like I was hit over the head when they said I had to give up my license. So now I'm in this position, and like I say, I understand your laws and I understand everything, but I would just hope and pray that you wouldn't take something that happened that many years ago, hold it over my head, take away something that I actually had to go to school for, had to learn every parts of the human body. This was hard, and I became good at it. I've been a massage therapist for 4 years with no complaints, no problems, and now I'm kind of lost, distraught, distressed. I'm all of the above because this has been taken away from me. The reason I decided to go into massage therapy was because I was a truck driver for so long. I decided to go ahead and retire with a business that I can continue to work and maintain a job. Like I said, right now I'm just kind of lost. All I'm doing now is DoorDash and applying for other jobs. But I'm 54 years old, with a bad back, and all kinds of health problems right now. And that's all I can say. I'm just
Thank you, Mr. Johnson. I appreciate you appearing here. Any questions, commissioners?
Mr. Johnson, hey, this is Commissioner Callis. I have a question for you. Have you ever had any other criminal history at all except in 1993?
Yes. Right before I graduated, I got charged with carrying a weapon on campus, which actually wasn't a weapon.
Yeah,
And
I'm not sure that was
I'm sorry, I know it's not a part. I was just trying to see about a past criminal history. That's all I was trying to figure out.
Any other questions? Okay. Mr. Johnson, I'm going to allow the commissioners to vote. Again, we alluded to this, that our lane is very narrow here. It is what it is. So we'll have to follow that rule. So commissioners, I need a motion.
I'll make a motion. This is Commissioner Callis. Mr. Johnson, I think the chairman just spoke very clearly to let you know I can't change the law. I can't change the statute. And I mean, I'm just being honest with you that if the law and the statute was not very narrow, I'm just going to tell you why I'm rendering what I'm rendering. The fact that you do have a history of prostitution and the law is very clear, I'm going to have to support the PFD. And I'm not saying that you're a bad person. I know you made a mistake, but it's so narrow. I just want to give you an explanation why I'm voting the way I'm doing, sir, out of respect to you.
So that's a motion to accept the PFD. Is there a second?
Commissioner Wesson, I'll second.
Any other discussion? Commissioner Castaneda, are you good? Just check in.
I'm good with it. I'm good.
All in favor, say aye.
Aye.
Opposed? All right. Thank you very much. Mr. Johnson, this is in the trail you can get with our staff to see what other options you may have. I appreciate your time. I appreciate your story, and hopefully the lane will widen. All right. Have a great day, Mr. Johnson.
you too.
Okay. We're going to go to number 4 because we got Miss Blackwell and Jessica. Ms. Hurtado, I'm sorry, Hurtado, I'm going to hold you. I know you're there. You got the next one. So we're going to hold you, and then we'll go from there. So Tamla, do we have Miss Blackwell on the line?
Yes, sir. She's here by telephone. Ms. Blackwell.
Miss Blackwell, can you hear me? You're on mute.
Yes, I can hear you.
Okay, good. This is Chairman Figueroa. You're going to have the commissioners listening to you. I'm going to read you some rules. I want to make sure that you understand, and then Mr. Thielen's going to jump. He's going to go first. So We'll hear from the prosecutor first, and you'll have an opportunity to speak after that. Make sure you speak clearly. Make sure you state your name. And each side is going to have 5 minutes. We may have a 3-minute rebuttal if needed. Please understand that the commission cannot hear anything outside the SOA hearing issues. I'll give you a little latitude and give you some personal information, but very little. I want to stay within those SOA lanes. So it has to do with what was said at the SOA hearing. Do you understand, Ms. Blackwell?
Yes.
Okay, great. Okay, so Mr. Thielen, you have the floor.
Trevor Thielen with the Enforcement Division. Y'all can hear me, right? I handled this case before SOA. However, no hearing was held in this case because after we filed a motion for summary disposition, the ALJ decided there were no factual issues that could affect the mandatory outcome of this case. We recommend you accept the ALJ's recommendation and revoke Sharon Blackwell's massage therapist license and deny renewal of it because the law requires you to do that. The statutes involved here are the same massage industry statutes you considered in many commission meetings over the last few years and in the previous case involving Mr. Johnson's license. The statutes are clear. Ms. Blackwell hasn't been eligible for a massage therapist license since 1994 because of a plea and a deferred adjudication for a prostitution offense. And even though she has held a massage therapist license since 1995, when DSHS granted her one, you are required to revoke it and you cannot renew it. The ALJ agrees you have no discretion. You granted the department's motion for summary disposition because no hearing was necessary to resolve the clear legal issues involved in this case. You should note the respondent did not file a response to our motion, as was her right. As a result, even though she indicated she wishes to speak to the commission today, she has made no legal arguments or presented any support for those arguments thus far. I urge you to keep in mind that the laws are mandatory for us and for you, regardless of any natural sympathy that may understandably be there if you hear about her passion for remaining licensed, the misguided approach from DSHS in renewing her license multiple times, and the time that has passed since the offense that required the license to be revoked that's elapsed. It continues to render her ineligible for the license, despite what's happened in the meantime. We recommend you adopt the PFD as written, adopting the minor citation changes the ALJ agreed were appropriate as the ALJ discussed in the exceptions letter. And I'd be happy to answer any questions.
Questions for Mr. Thielen, commissioners? Okay, Ms. Blackwell, can you hear me?
Yes.
Okay, you'll have 5 minutes. I want to caution you, the uniqueness of this case, the commission has a very narrow lane as to what it can do. The law is the law. And so regarding some of this disposition of these cases, so, but we still want to hear you, but, and you may hear the commissioners allude to it, but again, stay within the case, the SOA case hearing, if you don't mind, okay?
All right.
Thank you, Ms. Blackwell. Go ahead.
Okay, Ronnie Blackmore, the police officer, coerced me or entrapped me in regards to this arrest. I want to know where the recording is for proof.
I'm going to go ahead and object that we haven't had any evidentiary, even submissions beyond the court documents that we submitted in support of our motion for summary disposition. There was no response to that. There's been no preview of these legal arguments, of any evidence she might have to support them, no testimony from her. And I believe all of this is not something that you can consider, and that this really should just be based off of the law and any arguments about what the law requires.
I thought I'd get 5 minutes, though.
Ms. Blackwell, I need you to just stand by a little bit. Mr. Thielen, thank you. What Mr. Thielen is pointing out, again, which I alluded to at the beginning, you have to stay within the SOA hearing facts and findings. You cannot bring something that was not talked about or dealt with in the SOA hearing. So if this evidence is outside that, we cannot hear it. So you have to stay within that, with that lane, okay? And you'll have your time, I promise you. But I just want you to know that's important, because that's where we have to stay within that lane, okay?
Well, I don't know what a SOA hearing is.
Okay, the SOA hearing was with the ALJ when you heard your case. Was she present, Trevor? Were you part of that?
There was no hearing because we filed a motion for summary disposition and documentary evidence that really cut off the importance of factual fact-finding in the case in our position. Ms. Blackwell didn't respond to that motion, and so the judge was able to decide the case without having hearing. The judge canceled the hearing beforehand, and there was no testimony. There's no evidence in the case other than what was issued in support of my motion for summary disposition, which included the court records, which just simply record the fact that she pled to and was placed on deferred for a prostitution offense in 1994. That's really all the facts that we have in evidence in the case that could be argued about. How those facts are applied to the law, I think is fair game for her to get into, but not bringing in additional testimony about things that were never, ever discussed or even brought up.
Right.
I
Okay.
was not able to file a response because I didn't know how to do summary disposition. Mr. Thielen was supposed to help me. He never helped me. And the lawyer, the lawyer that was helping me at the time wouldn't help me either. So I didn't know how to do it. So that's the cards were marked against me from the beginning.
Okay, Ms. Blackwell, I understand that, but Mr. Thielen's correct that it talks about the prosecution, the 1994 case. That's where you can discuss how it applies to how the disposition of the case applies to you and the law, but you got to stay within that lane. If you want to speak to the commission, go ahead, Ms. Blackwell.
Well, no one will hire me due to this arrest because it's on my record. I thought I got expungement, but I got deferred adjudication. I found out later. They changed the law where I had to get fingerprinted in 2020, and that's when they found out about the arrest. I practiced massage for 26 years. I spent all that money on going to school and all my CEUs and keeping my license current. And I just think it's unfair that I was not able to, because I didn't know how to do the summary disposition. And then Terry Cooper later told me that this phone call was supposed to take care of the summary disposition. And then I got papers back from the judge saying they didn't understand the law and they had to reread the law, and the law changed some of the records in regards to my case. I didn't understand what was going on there either, and I had to wait for that.
I can clarify some of the things she's referring to.
I'm sorry, Trevor, say again.
I can clarify some of the things she's referring to.
Okay, give me a second. I want to make sure. Is there? Go ahead, Mr. Thielen. Go ahead.
I don't believe I offered her any help with responding to the motion for summary disposition. That would be impossible for me to do as the counsel on the other side. As far as what the judge filed in the case, she said, well, the judge claimed they didn't understand the law. What the judge did was refer to Texas Occupations Code 455-152 subsection A, which was an inaccurate citation of the current law. Complicated. We took out subsection B, which made the remaining subsection A, which has been in place for many, many years, no longer have that A next to it. And other respondents in other cases have used that to somehow say, well, this B part, which had a confusing language that we believe DSHS has properly sometimes referred to say we're only going to look back 5 years on these prostitutions instead of permanently. They took that out in 2019, the legislature did, and I asked the judge to just clarify and remove that little parentheses with an A in the middle of it from the PFD. Otherwise, it was kept the same. The judge agreed to that change.
Okay.
I don't believe the judge didn't understand the law or was confused. It was simply an old citation.
Okay, that's clear. Thank you,
Yes,
Mr. Thielen.
Mr. Thielen doesn't remember, but he said that he would fax me information in regard to the summary disposition. did.
Okay, Ms. Black, I need to recognize you before you speak, okay? Okay,
All right.
because we don't want to move ahead of ourselves. Just give me a second here. Commissioners, I need you to make sure we're up to speed as where we're at, and if you have any comments on this, I appreciate that.
Chairman, I will reserve my comments until after Ms. Blackwell's done, but I would like to bring up something after we make a decision on this case.
Okay, Ms. Blackwell, you have approximately about a minute and a half, but go ahead and you have a rebuttal.
Yes, Mr. Thielen said that he would fax me information on how to do the summary disposition. He doesn't remember though. Also, I have no other criminal records or arrests before this arrest. And like I said, I was entrapped into this over a child custody case. And I have proof of that.
Well, we can't bring that in, but I appreciate your comment. Let me get to the commissioners, see if they have any questions for you, particularly directly. Commissioners?
Mr. Chair, I do have a comment for Ms. Blackwell. Ms. Blackwell, because you've been working in this field for so long, and now I understand your perspective where you've been earning a living and now something has changed and that is being taken away from you. But I just want you to understand that the licenses have come over to our agency. The legislature in their wisdom representing the people of the state of Texas have decided that this agency would be better suited to administer those licenses based upon whatever their considerations were. And then they've given us law that we must apply to each licensee. And that's where you find yourself. That's one thing I wanted to say. The other thing is a bigger picture perspective of we have to acknowledge that human trafficking and human sexual trafficking is a horrendous crime that takes place in this state, in big cities and in small cities. And that's the backdrop within which we must administer the laws and the licensees. Okay, so that's something that's always a consideration, at least in my mind, and the good commissioners on this commission. We have to protect the most vulnerable of Texans, right? Those with no voice, those with no power, those with no money. And so this is an area where it's very sensitive to all of us, and we're all doing the best that we can to protect those with no power, and also making sure that people like yourself have their say and are heard and are protected as well. So I just kind of wanted to give you that. And I felt like I owed that to you because you've been working for 20 years in this industry, and now you're facing, yes, ma'am. Now you're facing the prospect of not being able to. So I wanted to give you some understanding of why this is happening to you instead of just this, huge state taking away your right to work in your chosen field. Okay?
All right.
Thank you, Commissioner Butler. Any other comments, commissioners? Okay. All right, Ms. Blackwell. Okay.
Yeah.
I'm gonna give you a 30-second to make sure that you understand what Commissioner Butler is communicated to you, but 30 seconds.
Yeah. I don't understand where trafficking comes into play here. I had nothing involved with any kind of trafficking for people that had no voice. I don't understand where that comes into play. And I was entrapped, and Ronnie Blackmore lied to me over 10 times in regards to this case. So I don't really feel that.
Okay. I just want to make sure I give you an opportunity. Okay, commissioners, I entertain a motion.
Mr. Chair, I'd like to adopt the PFD as written, and that's my motion.
Is there a second?
Commissioner Callis, second.
Okay, any discussion?
Mr. Chairman, can I chime in really quickly with the, there are a couple of technical corrections in the findings of fact 4 and 11 that we would recommend, just having to do with how the plea was characterized in the case, nothing that impacts the outcome of the decision.
You amend your motion accordingly, Mr. Butler?
Absolutely, Mr. Chair.
Okay, Dr. Callis, second stand.
Oh, yeah, I'll stand there, but I didn't realize we had technical corrections on this case. Sorry, but thank you, Mr. Bowman.
Okay, any discussion? Okay, all those in favor say aye.
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 Okay, motion carries. Okay, Ms. Blackwell, this isn't the end of the road. You will have an opportunity. The staff can contact you as what your next steps or options if you choose to do that. I appreciate your time. I understand it is confusing sometimes, but the staff will try to walk you through just make sure that you understand what just happened, okay?
Well, can I appeal this decision?
Yes, thank you. Thank you so much, Ms. Blackwell. I appreciate your time. Okay. Tamla?
Chairman, I had a question I wanted to bring up. Something that doesn't sit right in my gut, and I hope we can try to correct this, because it's like if I've applied for my medical license and the Texas Medical Board has my medical license. They say I can do and practice medicine. Then 26 years later, you're going to tell me I can't practice medicine from a technicality in 1987? I mean, I'm just saying, it doesn't make sense to me. I know I'm passionate about this because that's like a quid pro quo to me that you get. I mean, it doesn't make sense.
Dr. Callis, I personally, I'm in your lane, but we can't go off our agenda here. But I want this to be something.
I'd like to talk about it. Sorry, sir, and I'll be quiet. I know it's not on the agenda, but I think this needs to be discussed, severely discussed.
I completely, more than you know, fully agree with you. So we'll put that on, and we'll talk with staff about that. But yeah, this is something. But again, we can discuss it later. But I appreciate your comments, Dr. Callis.
Yes, sir. Thank you. Sorry to go off the agenda, Chairman.
No, Brad was going to put you in timeout, so I saved him from the effort of that.
Sorry, Mr. Bowman.
We're going to go on to Mr. Williams. Tamla?
Yes, sir.
Is Mr. Williams on the line?
Mr. Williams is not present.
Okay. Jessica Tata, you there? There you go. All right, I see you. All right.
Good morning.
So, good morning. You have the floor. And just FYI, after we do these two cases, I'm going to take a 5-minute break, and then we'll come back. So I'm giving everybody a heads up. Go ahead.
Yes, thank you. Jessica Hurtado with the Enforcement Division. Ken Sharp handled this case at SOA before he retired last year. The ALJ recommends that you grant Mr. Williams' application to renew his Class A barber license. We did not file exceptions in this case, and we do not object to the PFD as it's written. The respondent has been licensed as a barber since 1997. On April 25th, 2019, the respondent pled guilty to the felony offense of assault on a security officer, and the court placed Mr. Williams on a deferred adjudication for 3 years. According to Mr. Williams' testimony, in February 2019, he was visiting a cousin or a friend at the hospital when he was stopped and roughly treated by a security officer. The security officer injured his knee in the course of arresting respondent, which led to the felony assault charge. Additionally, according to the department's records, Mr. Williams submitted a late online renewal application on June 25th, 2019, and answered no to the criminal history question. However, respondent denied that he ever submitted his renewal application online. And according to Mr. Williams, he renewed his barber license in April 2019 while he was in jail awaiting the resolution of his case. The ALJ found that the department had failed to meet its burden of establishing that the respondent had knowingly made a false statement in connection with his renewal application. And additionally, the ALJ found that because of the felony assault was the respondent's only criminal offense, it was committed when he was 47 years old, and because he had been licensed as a barber without incident since 1997, the ALJ recommends that you approve the respondent's renewal application. The department does not object to this PFD, and I'm available to answer any questions that you may have.
Okay. Thank you. Commissioners, any questions? Okay. Should be easy. I'll take a motion.
Take a motion to approve the PFD.
Second.
Any technical corrections, Mr. Bowman? Okay. So we got a motion. We got a second. All those in favor say aye.
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 Opposed? Excellent. Motion carries. Thank you. Okay. Case Ibarra.
Mr. Ibarra is here. I'll move him from the breakout session.
Okay. Ms. Ibarra, can you hear me?
Yes.
Okay, good, good. Okay, I'm going to read you some instructions, and I want to make sure you understand, and then we'll go from there, okay?
Okay.
We'll hear from the prosecutor first, and then you'll be able to respond. Speak clearly, state your name and who you represent. Each side will have 5 minutes. There may be a 3-minute rebuttal, but please understand that anything you discuss has to be with what was discussed in the SOA hearing. And that's we're going to contain those comments to that, okay? I appreciate. Do you understand what I'm saying?
Yes.
Any questions?
No.
Okay.
Not at the
Okay.
moment.
So we'll go with prosecutor first, and I'll bring you in a minute. Hurtado, go ahead.
Yes, thank you, Commissioners. Jessica Hurtado with the Enforcement Division. This case had previously come before the commission and it was remanded back to the staff to work out an agreement to issue a restricted license. That agreement has been completed and Mr. Ibarra's restricted license is in place now. So we are asking that you dismiss the PFD.
Excellent. Commissioners, any questions? Yes, sir, Dr. Callis.
No, sir, I don't have any questions. We'll hear from Mr. Ibarra, but I have a motion, sir.
Okay. All right. Stand by a minute. Any questions? Okay. For Mr. Ibarra, do you have any comments?
No, but just that, I hope everything goes smooth and, I just hope I can stay in this field.
That's up to you, Mr. Ibarra. That is totally in your hands, sir. Any other comments from the commissioners? Okay, I'll entertain a motion.
Yes, sir. Chairman Callis, Mr. Chairman, my motion is to allow the dismissal of the PFD.
I think you're promoted.
I'd like to se- I would like to second Chairman Callis's motion.
I meant to say Chairman Figueroa. Sorry, sir.
That's okay. We'll put you in timeout in a minute.
All right.
Is there a second? Any discussion? Okay. All those in favor say aye.
Aye.
Opposed?
Aye.
Okay, thank you, Commissioner Castaneda. Opposed? Okay. Mr. Ibarra, couple points I want to make sure you understand that this is newly implemented law that was just given to you, which is an extreme amount of chance. You mentioned you hope you can stay in this line of business. I will petition to you very clearly, sir, that is in your hands now.
Okay.
Control has been put back in your hands. If you cannot handle it, it'll go back in our hands and it will not be well. So I want to make sure that you understand that this is something that the commission has fought for as a body, TDLR, who represents the state of Texas, the people of Texas have fought for this. So you're an extraordinary opportunity to do well. I would petition you for the second point that you are going to represent what we can do in the future. If it goes well, we'll be able to offer this to other people in the future. Do you understand, Mr. Ibarra?
Yes, sir.
I can't be any clearer than that. So hopefully you'll earn the grace that you've been given. Do your job well. Keep your nose clean. And hopefully in this context, we won't see you again, okay?
You won't. You won't.
All right. Thank you, Mr. Ibarra. Have a good day.
Thank you. Thank you. You too. Thank you.
All right. All right. Let's take it is 10:50. At 10:55, because I know that we're going to go through the case. I'm going to take a break. We'll come back, okay? Make sure you guys
Mr. Chair.
turn your mic. Yes, sir, Mr. Butler.
Before, slightly off agenda, could we take a minute or two to give Commissioner Callis a hard time for promoting himself?
I typically would, but I don't want to waste these poor people's times that are with us. But take the break. meeting back to order. It's 10:58, and we're gonna go to rules, and we're gonna skip I because Ms. Escobar is, I think, testifying with Mr. Francis right now. Is that accurate, Ms. Tama? Okay, so we're gonna skip I. We're gonna go to J, which is rules. Molly Fidel, are you there, Molly?
Yes, I'm here. Can you hear me?
Yes, ma'am. I see and hear you. So you have the floor.
Excellent, thank you. Molly Fidel, Assistant General Counsel here at TDLR, and I'm here today to present the massage therapy rules for you. These rules do three things. First, they implement the HB 2059 Human Trafficking Prevention Training requirement. That requirement's already in effect, so we are just bringing the rules in line with the statute. And as published, these rules would allow for that training to count for up to 3 hours of continuing education each license term. The second thing these rules do is they contain a clear requirement for the licensee to obtain a separate written consent from the client for each session involving breast massage of a female client. And third, the rules make clarification and cleanup changes. So these rules were published in the Texas Register on December 21st of last year. Excuse me, the 30-day comment period ended on December 21st. And we received 9 comments during that time. I'll give you a brief summary of the comments. 3 of the comments opposed the human trafficking prevention training requirement that is contained in statute. One of those comments stated that the time would be better spent in field-related continuing education. We also had a commenter, a comment who it seemed that they opposed the clarification change in 117.20. The commenter seemed to be under the impression that this would affect whether massage schools had to use the PALMS electronic system for reporting school hours, and these rules really do not affect that at all. The commenter also disputed our fiscal impact assessment, and when we received this comment, we went back and we re-examined that. And what we found was really that these rules that are proposed, nearly all of them do not change a licensee's practice. The only one that would is the one pertaining to the written consent for breast massage. And in that respect, any financial change caused by that rule amendment would be so small as to not have an impact on the licensee. We also received a comment stating that the requirement for the written consent prior to breast massage should apply to all clients, not just female clients. And that change is really something that's beyond the scope of these rules. If we wanted to implement that, we would have to propose changing many more rules than were part of this package. The rest of the comments were beyond the scope of these rules, are really not related to the substance of them. So next I'll go into the advisory board's recommendations. They met twice on these rules, first in October of last year, and they voted to recommend publishing the rules with the human trafficking prevention training counting for up to 3 hours of continuing education. And then they met again in January, and at that meeting they voted 4-3 for the human trafficking prevention training to not count as continuing education. And the thought there was that it really did not relate to the professional skills and knowledge that's required to practice massage therapy. The advisory board also recommended adopting the rules with 2 changes that were proposed by staff. They're very small. One is adding the word acceptable into the change in 117.20, and the other is withdrawing the change to 117.64. That was intended as a clarification, but we think that what was published would actually cause more confusion, so we'd like to just keep the rule as it is. Staff recommends adopting the rules as recommended by the advisory board. I'm here for any questions that you might have. I know I just threw a lot of information at you.
All right, Commissioner.
Yeah. Hey, Molly, this is Chairman Callis. I have a question for you. I know you made it. You said the vote was. I know I did it on purpose. The vote was 4-3, saying that the CEUs shouldn't be counted as CEUs. The reason why I'm just voicing my opinion. The reason why I think that's not appropriate is due to the fact that just because it's not in your specialty, you need to be trained and vigilant to understand what sex and human trafficking is in all specialties and in all professions. And so I think any time, effort in that seat learning about that, it does help your profession. So I just wanted to make that comment, and thank you, Chairman, for allowing me to make that comment related to the ruling that the advisory board did.
Well, thank you, third level, Dr. Callis, assistant. Any other comments? All right, I'll entertain a motion.
Chairman Figueroa, I would like to entertain a motion to approve the rules that Molly laid out very eloquently for us for massage therapy.
Is there a second?
I'll second.
I'll second that.
Excellent. Castaneda, Commissioner Castaneda, second. All in favor, say aye.
Aye.
Aye. Aye.
Opposed? Motion carries. All right. Thank you so much, Molly. I see Kabar is ready, so I'm going to continue on. And I told her to let me know if when she gets off the testimony, but we'll go to item K. Ms. Fitz?
Yeah. Good morning, Commission members. I'm here to present agenda item K, and this is 2 changes to Chapter 130 of the rules, or the Commission's rules. These are regarding the podiatry program. The first change that we have for you today is a change to Section 130.59. The amendments to this section will implement a process for waivers from the requirement for controlled substances issued with an electronic prescription here in the state of Texas after January 1st, 2021. Second change is the repeal of Section 130.74. That's a rule that's adopting a penalty matrix into the rule sections for Chapter 130. And our recommendation here is to repeal that section, and that's what's recommended by the advisory board. So let me give you a little background about these 2 changes, and I'll also discuss the comments that we received when we proposed this rule package. Section 130.59 currently contains all of the exceptions to electronic prescribing that currently exist in the Texas Health and Safety Code that implements the Controlled Substances Act. We are also required by the Health and Safety Code to implement an electronic waiver process. So to give you some background on that, we are currently in a situation where in Texas, if you issue a controlled substance prescription, Schedule 2 through Schedule 5, it must be issued in electronic format unless several exceptions apply, which are already in the rule, or you are granted a waiver by the licensing agency that issues your license. Since we are the licensing agency for podiatrists, we must implement a program to issue these waivers, and that's what we brought to you today here in these changes for Section 130.59. Just to be clear, this is a 1-year waiver, it must be renewed every year, and the process does allow the agency to review it. We can also deny it or revoke it for disciplinary action taken by the agency. All those are implementations that are in the rule section that we've proposed. The second section change is to repeal the requirement for a penalty matrix in rule. Originally, when the podiatry program came over through the Sunset Bill, there was a requirement to adopt the penalty matrix into rule. That's unusual here at TDLR. Normally, that's just put forward in the enforcement plan, and the enforcement division will present that to the advisory board and to you at the commission and make sure that that's published in the Texas Register, but it's not a rule section. That creates sort of a cumbersome process for the podiatry program, and it means that it's much slower to amend the penalty matrix for the podiatry program than it is for the other programs here at TDLR. So the recommendation is to repeal that rule section because the statutory requirement for having it in rule was also repealed in the last legislative session. So those are the 2 changes that we have for you in this package. We took this to the advisory board, the Podiatric Medical Examiners Advisory Board, back on December 7th. They voted to put these 2 rule changes forward in the Texas Register. It was published on December 25th, and the comment period stayed open until January 25th of this year. We received 2 comments on this package. The first comment was in support of the electronic waiver. This was a comment submitted by a doctor of podiatric medicine who felt that it would be very expensive for him to implement the electronic prescribing requirements because his practice issued so few electronic prescriptions or so few controlled substance prescriptions. The second comment was simply a doctor asking for the paperwork to actually request the waiver. And we've had a staff member reach out to that person and explain to them how the process is going to work. So there were no changes after those two comments. And the package that we brought to you today did not go back to the advisory board because we did not receive any negative comments, and time was of the essence in adopting this waiver process. So I understand that's a lot of information. I'm happy to answer any questions you may have, and I'm here for anything that I can do to help you understand the package.
Any questions for Mr. Phillips?
Chairman Figueroa, I don't have a question for him. I just want to make a comment. And I think it's very, I want to let the commission hear this comment. Opioid abuse and addiction is a very big problem throughout the United States of America, especially with human drug trafficking and with the use of all these different Schedule 2 through 5s. Yes, it's a hardship that all healthcare providers, from podiatrists to nurse practitioners to physicians, and anyone that can write controlled substances, had to go from a paper to electronic filing due to the fact that we're having finally a prescription drug monitoring program. So that way we can oversee to see if we can stop the fraudulent and the diversion of controlled substances. Yes, it's a pain, and it's a pain for all of us, but we have to adhere to the law. And thank you for bringing it up, Alex. And I just want to clarify to y'all that if podiatrists are complaining, they're not the only ones complaining because it's a change from the norm, but it's something that the state is requiring us all to do.
Good comments. Thank you, Dr. Callis. All right, I'll entertain a motion.
I make a motion that we adopt the rules as Alex proposed.
There's a second?
Second that, sir.
I'll second that.
All right, excellent. All in favor, say aye.
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 Those opposed? Motion carries. Thank you so much, Mr. Phipps.
Thank you, Commissioner members.
Okay, we're going to go to item L. Mr. Bowman, you got L and M. We'll do, you go ahead.
Thank you, Mr. Chairman and Commissioners. Brad Bowman, General Counsel, and I'll present these items to you. The first is Rule 60.351, which the Commission previously adopted on an emergency basis. And what we're putting in front of you today is to extend that emergency rule. The emergency rule you adopted on November 23rd of 2020. It went into effect that day. Was valid for 120 days. That 120 days is coming up. It expires March 22nd. And so you have the opportunity to extend that emergency rule for an additional 60 days, which would take us to May 21st. And at that point, the emergency rule would expire. We would have to go through the regular rulemaking process if we needed anything beyond that. A little background on that. This was part of the agency's efforts to respond to the COVID-19 crisis. And this had to do with delays and backlogs that we were experiencing in our licensing process and making sure that our licensees who were trying to renew and were experiencing some delays were able to continue to work. And so the rule that you adopted on an emergency basis authorized emergency licenses for those folks that where their licenses were expiring on or after August 1st. And it authorized the executive director to issue those licenses. And we have that up on our website. We're not actually mailing licenses out to people, but we have the information up on our website so you can look up and see who's been issued one of those emergency licenses. And it's just to make sure that the licensees didn't suffer or bear the brunt of any delays that we're experiencing because of COVID. There's been a lot of progress made in the department to address any backlogs and delays. I think you may be hearing about some of that from the executive office in the staff reports today, but we're not quite out of the woods yet. The licensing division has a lot on their plate, and so The reason for extending this would be to just give some additional latitude to the executive director if we need to keep extending that out and issue some additional emergency licenses so that our licensees can continue working uninterrupted. And so that's what's in front of you today to extend that emergency rule by an additional 60 days to March 22nd. And I'm available to, to May 21st, and I'm available to answer any questions.
Thank you, Mr. Bowman. Any questions? Excellent. Staff's done an extremely wonderful job of putting this together. Thank you so much. I'll entertain a motion.
Mr. Chairman, I recommend that we follow Mr. Bowman's suggestion that we extend for another 60 days due to the fact of the coronavirus pandemic.
I'll second that motion. I'll second that.
All right. All those in favor say aye.
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 Opposed? Motion carries. Mr. Bowman, item N.
Thank you, Mr. Chairman. This is a little different item. These are rule reviews. There are 11 of them that we published in the Texas Register. And so as a reminder, the Administrative Procedure Act requires that all state agencies review their rules every 4 years. And the primary purpose is to determine whether the reasons for adopting the rules still exist. Those rules still needed? Are there any changes that need to be made to those rules, et cetera? And so we have gone through kind of the initial step of this process. We published the notices in the Texas Register that we're reviewing these rules and inviting the public to comment. So it's a 30-day public comment. Those comments are in your materials, and we've given you summaries of them. I won't go into detail about them at this time, but we did receive some comments on some of those programs that are up for review. At this point in the process, we're recommending that the commission readopt all of these rule chapters. We would publish that in the Texas Register. However, there is a what we call a second phase of our rule review process, kind of the way we do this at TDLR, that's already underway, and that's a more substantive deep dive into the rules to determine whether any changes are needed. If there are any changes that would come out of that process, we'd have to start a whole nother rulemaking and give the public notice of what those changes would be, or any rules that might be repealed or amended, and so forth. So we can't make any changes to the rules here today. The only thing that's really in front of you at this point is to readopt them. But I did want to let you know, first of all, that more in-depth review is underway, and so you may be seeing in the coming months proposals that would come back, that would work our way through the regular rulemaking process through our advisory boards, and then come back to you for adoption, like you've seen some of the rules here today. As part of that, we will take the public comments that we got in response to this proposal, and that will figure into the staff's work on any potential rule changes going forward, and as well as the advisory board. I wanted to take a minute just to tell you a little bit about this rule review process and some changes that are underway in response to the sunset process, and it does impact these rule reviews that are in front of you. So the Sunset Commission's report that came out made a number of recommendations for changes at the department. Christina Kaiser has been leading the team that is responding to all of those management actions and implementing them. A piece of one of those recommendations from the Sunset Commission had to do with this rule review process. And they want to kind of twofold. They want to make sure that we are doing a thorough in-depth review of all the rules when we do a rule review. And secondly, they want to see that we're incorporating some data and analysis of data into the rule review process. And that's kind of a new element that we're working on. So for example, enforcement data showing what rules are, what enforcement actions there are, how many enforcement actions there are, for example, on particular rules. And that might guide us in terms of what changes might be needed or rules still necessary, and so forth. So on that piece of this, we have implemented a pilot project where we're taking 2 of the programs, water well drillers and pump installers, and orthotists and prosthetists, 2 kind of different programs. One's a health program, one's not, to get a good sampling. And we are having the internal discussions and pulling data and trying to factor that into these rule review discussions. So we're going to see how that goes. We'll learn some things from that pilot project, as Randy might describe it if he were here, a safe to fail experiment. And then we will apply those lessons to the entire rule review process going forward. So down the road, we're working on changes that would amend this entire process. And I'm obviously not moving around in my office enough because the lights just went off. But so that's in a nutshell the rule review process. I wanted to kind of give you some texture to that so you sort of understand what we're doing beyond just what we're putting in front of you at the moment. With that, I'm available to answer any questions. So the bottom line is we're asking you to readopt these rules with an effective date of March 15th at this point.
Thank you, Mr. Bowman. I'll send my assistant to make sure that you have a light. Don't worry about it. It'll find a purpose. All right. Any questions for Mr. Bowman? All right. Great job. Thank you so much. I'll entertain a motion.
So, Mr. Bowman, to be clear, all you're asking for today is for readoption of rules, correct?
Yes, sir.
Okay, so I make a motion that we readopt rules that Mr. Bowman laid out.
I'll second.
Any further discussion? All those in favor say aye.
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 All those opposed? The motion carries. Okay. All right, we're going to jump back to item I. Ms. Escobar's there. I think that's accurate. You know, it's been an extraordinary year, just for the record. We got COVID, snowstorm, sunset. We have testimony going on right now in front of the legislature. You have us doing this. You know, I'm waiting for the second coming. I'm not sure what's next, but good God help us. I think we're going to manage this well. So thank you, Jessica, for juggling, finding a room in the Capitol. So you have the floor. We can't hear you, Jessica. I don't know if your mic is not working. You look like you're muted. It's just we can't hear you. Is that the governor's office that I see you in? Did you snuck into the governor's office? We can't hear you. I did a whole drum roll. I propped you up, and I can't hear. Can anybody hear? Or is it just me? Okay. We'll give you a minute. Don't worry. No. Can't hear you. No. No. Yeah, Jessica, you want us to come back in a minute? Okay, we'll come. We'll give you. We're gonna go through appointments, and then Mary, you available, Mary?
Yes, sir, I am.
Okay, it's your time to shine. Jessica, just you got my number. Let me know. Text me, Mary. I may pause you because I know she's in between, and I'm gonna. So just forgive me for that. If I have to, I'll pause you so she can jump in, and we'll go from there. Okay.
No problem. I'm reading from a report, so stop me whenever you want to. Mary Winston, TDLR Advisory Boards. Today, I'm going to read our list of reappointments and appointments for approval. The applications and information has been given to the advisory board members. I'm sorry, I'm so used to saying that, to the commission members for review, and I just want to read those off today, and stop me whenever you need to, Chairman. First, for our appointments, we have for the Advisory Board of Athletic Trainers, we have Mr. Ronald A. Bear III of Cypress, Texas. We have next the Architectural Barriers Advisory Committee, Ms. Jody Nake of Bay City. For Behavior Analysts Advisory Board, we have two new folks for appointment, Mariel Fernandez, Houston, Texas, and Brian Findley of Dallas, Texas. For the Board of Boiler Rules, we have Palmer Dent III of Cypress. Code Enforcement Officers Advisory Committee, we have Hubert McKinney of Pecos, Texas. For our Combative Sports Advisory Board, Roger Temple of Magnolia, Texas. That's Dr. Temple. For Driver Training and Traffic Safety Advisory Committee, we have Dr. Julie Chancellor of Kingsville. For our Hearing Instrument Fitters and Dispensers Advisory Board, Dustin Potter of Wichita Falls. Registered Sanitarian Advisory Committee, Kent Manton of Garland. For reappointments, those who are already part of this wonderful system and are up for reappointment today, for Air Conditioning and Refrigeration Contractors Advisory Board, Mr. David Morris and Ms. Suzanne Smith, both Austin. For our Behavior Analysts Advisory Board reappointment, Dr. Joyce Mock of Fort Worth and Ms. Carol Sloan from the Woodlands. Board of Boiler Rules, we have Alan Kripe, Temple, Texas, and Brian Malin of Santa Fe. Code Enforcement Officers Advisory Committee, Ms. Teresa Adrian of Irving, Texas. Driver Training and Traffic Safety Advisory Committee, reappointment for Mr. David Bruce of Houston, Texas. Dyslexia Therapists and Practitioners Advisory Committee, Ms. Helen Masick of Dallas, Texas. Electrical Safety and Licensing Advisory Board, Marcus Lundgren of Amarillo. For Hearing Instrument Fitters and Dispensers Advisory Board reappointment, Lance Brooks of Paris, Texas. Licensed Breeders Advisory Committee, Ms. Andrea Gregg and Cynthia Rothermel. For Midwives Advisory Board reappointment, Dr. Michael Nix. Orthotists and Prosthetists Advisory Board, Ms. Catherine Mize of Double Oak, Texas. For Registered Sanitarian Advisory Committee, Dalton Ray Knight Jr. of Flint. For our Tax Professional Advisory Committee, James Ratloff of Lubbock and Gary Ernest, also of Lubbock. For Towing and Storage Advisory Committee, we have Thomas Griffin of Houston and Kyle Jackson, Austin, Texas. Used Automotive Parts Recycling Advisory Board, Kaylin Thomas of Waxahachie, Texas. And for Weather Modification Advisory Committee reappointment, we have Ms. Aurora Farthing of Lubbock and Alan Zeman of Pecos. Finally, we have presiding officer appointments, and we just have a couple of those. For our Hearing Instrument Fitters and Dispensers Advisory Board presiding officer, it's Lance Brooks. And for Orthotists and Prosthetists Advisory Board, we have Ms. Catherine Mize of Double Oak. And that is the end of my list, I think. Yes.
Is Catherine Mize a presiding officer? Is that accurate or no?
She is. Miss Mize is reappointed and to the board, and she will also now, if the commission sees fit, be the presiding officer. And she's actually one of the founding members of this board. Great servant and public servant, and she's the only woman on the board. Not that I'm biased at all, but I think this is fantastic.
No, I thought I just had them switched, so my apology. I wrote the wrong name down. Thank you. Okay, first, thank you, Mary, for doing a great job, and I would like to personally congratulate the advisory board members for what they're doing. It is yeoman's work, and their information about these industries that we're in charge of is invaluable. So I cannot tell you how much we appreciate it. So express our thankfulness and appreciation. Okay?
Thank you.
Mary.
Thank you.
Okay. We're going to go back to Jessica one more time. Jessica, you're on mute, so.
I should be working now. We good?
Outstanding.
All right, I had the iPad just in case, so we'll put that away.
No, I
All
usually mute Dr. Callis, but I won't mute you, but we're good. Okay.
Not Dr. Callis, not right now. Now really thank you, commissioners and chairman, for your patience with me this morning. It's been a great morning here at the Capitol and in-house appropriations. I am here to present the auctioneer rules. They were proposed, and they are proposed rules that amend the licensure requirements for auctioneers, removing which automatically prevents an applicant with felony conviction from being licensed. This means that those cannot be by TDLR during the license if that individual is not automatically disqualified from applying if they have a felony within the 5 years of seeking licensure. The rules were proposed in the November 6th issue of the Register. 14 comments were received, and they were all opposed to the rules. The comments generally were against the rule because of that position of an auctioneer. The proposed rules were necessary to implement changes that were passed by Senate Bill 1531 during the last legislative session in 2019. Therefore, it is required to implement this rule change, and no changes were made as a result of the comments. The auctioneer board met on January 7th to consider the changes and to consider the rules, and they recommended that the rules be adopted without changes. And commissioners, I am asking that you adopt the rules as presented with an effective date of April 1st, and I'm here if you have any questions.
Okay, real quick, we're going to go back to the appointments in a minute, but any questions for Jessica? All right, I will entertain a motion.
I will make a motion that we adopt the rules as Jessica laid out.
Second?
Second, Mr. Chairman.
Second that.
Okay, all those in favor say aye.
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 Opposed? All right, motion carries. Jessica, thank you. Make sure you slap Brian on the back and tell him to keep the Dog and Pony Show going, and I hope everything goes well, and doing a great job. Appreciate the effort.
Thank you all. Have a great day.
Thank you. Okay, I messed up. We need to go back and vote on the appointments, but I think Mary wanted to add a comment. Mary, you still there?
I am, and we both messed up, Chairman, because I skipped one thing as I was going back and forth. Thank you, Christine. She's apologizing in the background, and I'm like, nope, you didn't mess up. That would be on me. So we have presiding officer reappointments, and we have two of those. We have for Speech Language Pathology and Audiology Advisory Board, Sherry Sensibrian. And for Used Automotive Parts Recycling Advisory Board, Mr. Chad Tearmina. And forgive me, Chad, if I have mispronounced that. And that's it. And with that, that is the end of the memo that is supported by the documents that you all received in preparation for the meeting. And I will hand it over for the commission to now take a vote.
Excellent. I'd like to thank them as well and include them in the thank you. And give me a minute and I will blame it on Dr. Callis, where we both put him at fault, which I need a couple minutes to figure it out. All right, I will take a motion to vote on the appointments and reappointments.
Mr. Chairman, I make a motion that we support Ms. Winston's power presentation and accept the appointments and reappointments of the different advisory boards and committees.
Is there a second?
I'll second that motion.
Excellent. All right, all those in favor say aye.
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 All right, motion carries. Thank you so much. So there's a technical glitch and I caused it, so I appreciate y'all's latitude with that. Staff reports. I think we've got Mr. Mendez and Ms. Kaiser. I think you guys doing, or somebody's doing it. Y'all go ahead.
Sir, Mr. Chairman, Mike Mendez, Deputy Executive Director. I'm going to give you a couple of items on the staff report, and Deputy Executive Director Christina Kaiser will do the remaining. I'm going to provide you the legislative update and also kind of our hub report. But just so you know, as you're aware, legislative session has begun. And as we were speaking and finishing up the last rules, Ryan had just finished his testimony in the House Committee on Appropriations. So that has been completed also on the House. He was in Senate Finance yesterday. So we've already begun to start the process of testifying before the legislature. Because of COVID and the various things that were taking place there, the session has started out a little slow, but they're starting to pick up some steam. More meetings are beginning to be held now with committees. So I can tell you that we're currently tracking 203 bills through Telecom. I do want to give a shout out to Jeff Kopis, who kind of keeps us in the loop and lets us know what's going on there. Does a great job of tracking all the bills and putting them before us so that we know exactly which ones are coming, which ones have been filed. So he's done a great job in that. Would let you know also that as you're aware, Eric Beverly, who's now our Director of Field Inspections, has moved on to that particular division. And Jeff Kopis and Jeremiah Kuntz are now in the Government Relations team. So we look forward to having them help us out in that particular manner and keeping us track and making sure that we're aware of everything that's going on. Of the bills that have been filed, the 203 that we're following, I can tell you that we have several that we're monitoring that are new bills, would be new programs coming to us or transfer programs. And so we're kind of keeping a close eye on that. That goes from sports wagering to emergency vehicle metering to sports betting, and so some new creations of some health related programs also. So we're monitoring that and letting that come to us. I will let you know also on the hub side and the mentor protege, we are continuing to develop that side of our agency. Our Director of Finance, Randy Corrales, is doing a great job of doing that. We actually have a hub event scheduled for Friday. So we're looking forward to having continued vendors come into our agency and begin to start working with our agencies that are hub related. Our numbers seem to be kind of going up, and they're doing really well when you begin to start taking a look at our hub numbers as they compare to state agencies. So I'm available for any questions that you might have. I want to kind of keep it short because I know that you've gone through a lot of cases today. So if you have any questions for me, I'll be more than happy to answer them.
Any questions?
If not, I believe now Deputy Executive Director Christina Kaiser is going to provide the next section of the staff report.
Good morning, Mr. Chairman and Commissioners. I'm Christina Kaiser. I am also one of the Deputy Executive Directors here at TDLR. My area of responsibility is regulatory affairs. I'm going to talk with you today specifically about a couple of items in the executive staff report, the COVID update and the update on delays, changes, and improvements in TDLR's licensing process. I'm going to cover both of those together. So as you are well aware, COVID has affected our staff, just like it has affected other organizations in the state. We have had to shut down our mailroom a few times, as well as pockets of staff in licensing and other divisions as well. With 40 programs and 8 different licensing systems currently, COVID has definitely revealed the weaknesses in our current processes in licensing. Some of those processes are still very manual, meaning that they're very paper-based. The Texas licensing system, which is on our horizon, will definitely help with these processes, but it will be some time into the future before that system is a reality. So in the meantime, we have taken some actions to help with moving the backlogs of work along that we have currently been experiencing because of COVID. In financial services, I believe we briefed on this last time. At times during the pandemic, in financial services, we were 2 to 3 weeks behind in processing money mail. Over the last few months, we have studied our processes in the mailroom and elsewise in financial services and achieved some process improvements by jettisoning some procedural steps that really added no value. As a result of that, we are caught up in financial services, and that what that means is today we are processing today's money mail. So in the licensing division, that process of bringing everything up to date in financial services resulted in a huge slug of work that had been backed up in financial services, now moving on to licensing. And so licensing, which had already been struggling with backlogs from time to time, now has this huge new stack of work looking at them. So we have, to assist licensing, we have reallocated staff from other divisions to help with licensing. We are calling this the Strategic Workforce Allocation Team, or the SWAT initiative. And we're hoping that will help bring down those backlogs and turnaround times. Practically every division in the agency is offering some amount of assistance for licensing. I can tell you that from my divisions, I currently have at least 15 people in field inspections who are assisting licensing, 23 people in regulatory program management, and 17 people in enforcement. And I want to emphasize that throughout the pandemic, this has been something that licensing has struggled with, and other divisions in the agency have been assisting at various levels across the last year. Other divisions have also assisted financial services at times. But recently, additional staff were recently volunteered from multiple divisions to assist, as I described, because of financial services freeing up a whole lot of work. Those volunteers, those recent volunteers, are being trained now by licensing, and they will be getting to work soon. Other things that we have done to respond to the backlogs were touched on earlier. That included extending the emergency licenses now through March 15th. And the action that you took earlier to continue the rule for emergency license extensions. I would like to also talk a little bit about the last item on the executive office staff report, an update on the proposed rule amendment to reduce the fee for obtaining a criminal history evaluation letter. I'll mention to you, and thank you to Brad for updating me on this. The comment period for those proposed rules closed on February 22nd, and we plan to have that rule on the Commission's agenda for possible adoption at their next meeting, which may be April 27th or May 4th. This rule would reduce the criminal history evaluation letter fee from $25 to $10. And I'd like to tack on to that. This rule amendment is an example of a second chances initiative. And by that, I mean an effort to reduce barriers for individuals with criminal convictions who are attempting to re-enter the workforce. Our chairman, Figueroa, has been a passionate leader on the topic of second chances. And on that note, I'd like to mention that our Second Chances video that features Chairman Figueroa has now been posted on TDLR's YouTube channel and is live and available for viewing. We will begin promoting this video on social media tomorrow. This concludes my report, and I'm happy to answer any questions that you have.
Anybody but Dr. Callis can comment, please. Anybody but us, please. I'm just asking.
I would just like to say that kind of echo what you said. Chairman Figueroa has been passionate about this, and I know this is something that's been close to his heart for a long time. Back when I was skipped over for chairman, he came to me and said, Tom, I would like some help in this area. And this is something that's close to my heart. And it's what we face every day, right? Today, people with criminal histories coming to us, asking for a second chance. Sometimes they get it, sometimes they don't. But this is kind of one of the most important things that we do and one of the hardest things that we do, because reasonable people will differ on some of these cases. So again, I just want to thank the chairman for all that he's done to push this forward. And so I will be able to say one day, I served on that board when Chairman Figueroa put this through the upright. So thank you.
I'll give you the $20. You said it just like I wrote it. So thank you. Appreciate that, Commissioner Butler. Anybody else? Okay, real quick, Mike, Christina, thank you. David, I know is not here. Brian, necessity is the mother of invention. I think that this whole COVID, one of the fruits will be the efficiency by which we operate will be unprecedented at every level. And you guys have embraced it. COVID, sunset, snowstorm, legislative sessions, mask, no mask. Events. It is unprecedented what's been thrown at us. And I think we are going to be an amazing agency. And I would turn to my testimony at Sunset was that we have earned, and I've spoke at a couple policy functions, we've earned a reputation in the state, and it's because of you guys. And our job is to get out of the way, and you have what you need to succeed. So thank you guys for that. And we're going to be, we went from TDLR 2.0 to TDLR 5.0 is what we basically did. And so extraordinary efforts. Thank you guys, and we appreciate it. I think that's it for now. Any other comments from the commissioners? We will have a subcommittee and Dr. Callis on a legislative issues, on some legislative things that were mentioned in this meeting to start looking at what we're going to do. So fear not, you were heard and people were heard. So so look for that phone call. Our next meeting date, Tamela, have we figured that out?
I have not heard from all the commissioners, so I don't have a date yet.
And I think, did we miss everything? We got the minutes approved. Everybody's voted on, correct? I think it was.
Yes, sir.
Sure. Okay, good. Okay, I want to make sure that was good. I think that's it. Guys, thank you so much, Commissioner Castaneda. I know you've been on the phone for a while, and I appreciate every effort that you make to be here. I appreciate you all, guys. I feel like the commission will drive back to the core issues pre-COVID. We're working back through it, and we're gonna do exceptional. It's gonna be an exceptional year, 2021. So hang on, guys. All right. Y'all have a great day. Thank you.